Good afternoon, everyone. Thank you for attending the February session of a DVAP CLE titled How to Probate a Will. Today, we have the pleasure of hearing from Jack Wilburn. Jack is a sole practitioner focusing on the areas of probate, guardianship, and estate planning. He has previously served as the chair of the Probate Trust and Estate section of the Dallas Bar. He has clerked for the Honorable Nikki DeShazo in Dallas County Probate Court and the Honorable Russell Austin in Harris County Probate Court Number 1. He has his JD from the University of Houston Law Center and his Bachelor of Music Education from McMurray University. When he's not working, which he does a lot of, he loves to explore national parks with his beautiful wife, Amy, and they're up to 28 parks visited now. So without further ado, I would like to pass it on to Jack, who will provide our presentation this afternoon. Thank you, Jack.
Thank you, Maricela. I appreciate that. Welcome, everybody. Bear with me here. I always struggle I'm sitting in my office by myself talking to people I can't see. So uh, I do the best I can with no feedback. It reminds me of when I used to coach my son's little basketball team, the Tiny Tar Heels. I would be talking to them about a 1-3-1 zone, and they would just look at me with blank faces. So I'm just looking at a blank room, and maybe not. I'm connecting with you, but I thought I'd start with a disclaimer today. This is why people hate lawyers, because we believe in disclaimers. We're going to talk for about an hour today, and at the end of this, number one, this topic could be an entire day of CLE. It could be an entire week of CLE. It is one of those topics that is simultaneously very simple and very, very complicated, depending on the facts and circumstances. So I do not expect anyone to be an expert at the end of today at 1 o'clock. Hopefully you'll know more at 1 than you do right now. This presentation is geared towards, I'm assuming most people that are on here have volunteered to take a DVAP pro bono probate case. And you're an amazing lawyer that practices in mergers and acquisitions or family law or criminal law or something uh, much more complicated and much more difficult than what I do. And so this is just a little primer to get you up and running to understand how to probate a simple will. Uh, but as you know, quite frankly, if I was as smart as y'all, I'd be doing something really complicated, but I'm not very smart. So here I am showing you how to do something simple. This is a very high level overview of a very detailed process. Um, It'll give you the lay of the land. I hate corporate speak, but I think the phrase is 30,000 foot view. We're just going to kind of fly over this, and I'll point you to some things that you can use later. Uh, I think generally we send out this presentation to anybody that's on here, so you'll just have this as a reference. Um, the most important thing is to just check in with the court you're with and do what they tell you, and you're going to be fine. There's no way I can cover every fact scenario that's going to be covered. And here we go. So you you've agreed to take a pro bono case, and you have been assigned a client, and they brought you a will. Now what? So we're going to talk about how to do the initial consultation, how to look at the will, how to draft the application, how to file it, or what's involved in that, getting through the hearing, and getting to letters. This is all about getting to letters. Uh, Either letters testamentary or letters of administration with letters of independent administration with will annexed. And we'll touch very briefly on estate administration, which is what you do after you get your letters. So let's delve into this. You meet with your client and you review the will. So ho as I've said, and usually the presentation I give for DVAP is an intestate CLE, where I tell people that 70% of the population dies without a will. So uh, I'm no genius, but I think that leaves 30% that died with a will. So you're already ahead of the game. If you're meeting with somebody and they've brought you a will, you're doing good, and it's going to make your life easier having a will. Um, when they come, you're also going to want to look at the death certificate. The couple of things you're looking at is how long has the person been dead? Have they been dead less than 4 years? That's the general time frame we have to probate a will, 4 years from the date of death. Um, Also, we're looking at names. What name is on the death certificate versus what name is on the will? And we'll talk about that a little more in a minute. And we're gonna look at where did they die. That is an important aspect of venue, which is under Texas Estates Code 33.001. Where am I going to probate this will? Now, this presentation is geared towards folks that are taking cases and filing cases in Dallas County. Almost every probate lawyer I know practices in all of the counties in North Texas. And so every county has its own little way of doing things. One of my uh, mentors over the past 20 years is a lady some of you may know named Carol Dabner. She always told me every court is its own kingdom. And so what I'm telling you today applies in Dallas. For the sake of your own sanity, do not go to another county and say, well, this is how they do it in Dallas, and vice versa. So, take a look at the death certificate. How long has it been since they died? What's the name? How does that relate to the name on the will? And where did they die? And am I going to be able to probate this in Dallas County? So, the next thing you want to talk about is what are the assets we're talking about? One of the things I talk to clients about is that there are two kinds of assets in this world. In the probate world, there are probate assets and there are no non-probate assets, and all assets fit into one or two of those categories. If you have an asset that has a beneficiary designation or any way to pass directly upon the death of the decedent, that is a non-probate asset. The general list of assets that fit in that category are life insurance policies that have surviving beneficiaries, 401ks, retirement accounts, bank accounts that are joint tenant with rider survivorship, or bank accounts that have what we call PODs, payable on death provisions. Assets held in trust are not considered probate assets. And so everything else is a probate asset. Generally speaking, when you're sitting down with someone, they're going to have a mixture of probate assets and non-probate assets. The most common probate asset I see is a house, some cars, the stuff that's in the house, and depending on who survived them, we may have a bank account, we may have some retirement accounts. It just depends on if beneficiaries survived uh, the decedent. So in some instances, you can have a non-probate asset that accidentally becomes a probate asset because there are no surviving beneficiaries. Prime example is usually going to be a second to die spouse. So husband and wife name each other as beneficiaries on life insurance policies. Husband died 10 years ago, and now you're dealing with the estate of the now second deceased spouse. And so, yes, there was a non-probate asset, but because the husband predeceased, it's now going to be a probate asset. So you just want to delve into all of that, ask those questions, because as I like to tell my clients, just because you have a will doesn't mean you have to probate it. And the only reason to go through probate is if there's something that needs to be passed through. And so that leads us to, is there a necessity for administration? Are there assets that need to be passed? Are there debts that need to be paid? Or uh, if it if all you really need to do is pass title to real property, uh, otherwise there's no necessity for administration, you might consider a muniment of title, and we'll talk more about that here in a minute. Um, the other thing you want to do in this meeting, but the most important thing you're going to do is look at the will and look at the death certificate and talk about the assets. But then, just on a housekeeping note, you want to gather information that you're going to need for the application. You're going to want to know the name of your applicant, their address. Uh, Stupid me wrote last four of social and driver's license. That's supposed to be last three. That's just common practice now for the applicant and for the decedent. You need the last three of the social, last three of the driver's license. Uh, it's not uncommon to not be able to have or know the last three of the driver's license of the decedent. In my applications, I just put, we don't know it. Uh, you'll know the last four of the social because it's on the death certificate, hopefully. All right. And you need to know who's going to serve as the executor or the administrator. Most times, the person you're meeting with in a consultation that brought you the will is also the person who's named in that will as the executor, but not always. So you just need to make sure you know, okay, well, you're bringing me this will, but you're not named as the executor. We need to talk about that. Are they willing to serve? Are they still living? Are they going to be involved in this process? And you just need to have an understanding of that. So those are sort of the things you want to take away from the initial consultation. And that'll get you started. Asking really good, thorough questions on this front end is going to make your life a whole lot better on the back end and just set you up for success in order to get your will admitted to probate, get an order admitting the probate, which is what you're looking for, and getting letters, which is what you're really looking for. So, you also want to talk to the person. Uh, Assuming the client you're talking to is also the named executor or going to serve as the administrator, you want to ask them if they're qualified and not disqualified, suitable and not unsuitable. And those are all the questions that are in what we call the proof addendum in Dallas County. Are you over the age of 18? Are you a resident of the state of Texas? Have you ever been convicted of a crime uh, of moral turpitude? Have you ever been convicted of a felony? Those kind of questions. And my understanding is that once you accept a DVAP case, they give you the forms you need to get a will uh, admitted to probate in Dallas County. So you'll see that as part of the packet you get. All right. So we talked about looking at the will. What are we looking for? Um, you're gonna you're gonna look at Texas Estates Code Chapter 251 to understand what you're really looking for. But the most important thing, just from a practical consideration, somebody walks in, they show you the will. Um, is it the original? Well, Jack, how do I know if it's the original? Well, one clue is if you're looking at blue ink um, signatures. Another is if the notary stamp is a raised seal. Like some notaries have a crimper where it actually creates a raised notary seal on the document. And our office, we use notary stamps. We use blue ink in our notary stamps, which should be one indicator. But an old trick I learned way back when I was clerking for Judge DeShazo, sitting with Rita Trammell, she would lick her finger and rub it across the notary seal. And if it would smudge, she knew it was an original. If it didn't smudge, we had to do further investigation. So you just want to make sure that you've got the original. it's not fatal if you have a copy, but it just makes your life a whole lot easier if you've got the original. Um, you also need to make sure you understand that the person who signed the will that we call the testator, were they over the age of 18 the day they did the will, or were they married or in the armed forces? Um, and were they of sound mind? Did they know what was going on? Now, the other thing you want to know is this a typed will or is it holographic? Again, this is all of this is under Chapter 251 of the Estates Code if you want to look at more specifics. But just from a high level, you've either got a typed will that is signed by the testator and two witnesses, or you've got a will that's solely in the handwriting of the testator. That's holographic. It doesn't require witnesses. And so that's what you're looking at. A vast majority. I've been doing this, my God, uh, 20 something years. I think I've probated five holographic wills. A vast majority of the wills you're dealing with are going to be typed, um, and a very small percentage of them are going to be holographic. But it comes up, so be aware. And just because they're holographic doesn't mean there's anything wrong with it. You can still get it admitted to probate just like a typed will. Um, is it from the state of Texas or did it come from another state? Is this a Tennessee will or a Nebraska will or a will from Washington State? Or is it from France? Is it from Italy? Is it from Mexico? And again, all of this is covered under Chapter 251. It just changes how you probate it. But my goal is to, if I'm sitting down with somebody, well, number one, I think we all understand this. Generally speaking, if I'm talking to someone, nothing good has happened. They're sitting across from me because a loved one has died. So I'm trying to make their life better by helping them as much as I possibly can. So I'm not looking for problems. I'm looking for solutions to problems. So I try to have a solution for every problem. Oh, you have a will from Tennessee? We can take care of that. Oh, you have a will from Mexico? We can take care of that. Oh, it's holographic? We can take care of that. But there are certain things we can't do. Oh, this is a printed out copy of a draft of a will that was never signed. I can't probate that. So just make sure it's signed, make sure that it's witnessed, make sure that it's the original, um, and just understand where it's from and what it is. Is the will validly executed? So, is it signed by the testator and two witnesses? Again, this is if it's typed. Is it signed by the testator and two witnesses? And that's what it takes to make a valid will in the state of Texas. We'll talk about something called a self-proved will in just a second. But if all you have is the signature of the testator and one witness, you don't have a valid will. It takes two witnesses for it to be a valid will in the state of Texas. Unless it's holographic, then all you need is the testator's signature. Is it self-proving? Um, you basically, the way this works is if it's done by a lawyer or if they followed good directions off the internet, you've got the testator, two witnesses, and a notary all sitting together, and everybody signs everything in front of each other. The testator signs the will, the witnesses sign the will, and then the testator and the witnesses and the notary sign the self-proving affidavit. And all a self-proving affidavit does is make a will where you don't have to bring the witnesses into court to admit the will to probate. So it's an easy button, if you will. It's an easy way to get the will admitted to probate without having to drag witnesses or the notary into court. So it not being self-proved is not fatal. The next thing I'm looking for is, does the will name an independent executor? Um, I'm an eternal optimist, so when somebody hands me a will, I am believing in my heart of hearts that it's the original, that it names an independent executor to serve without bond, and that it's a state of Texas will and it's signed by the testator, that it's signed by two witnesses, and it has a self-proving affidavit. So I start from a positive position and then I go from there. And I am looking for, does it name an independent executor to serve without bond? That's the easiest will to admit to probate. It has the least amount of complications. Uh, Generally, well, depending on how thick the will is, what I've learned over the years is the thicker the will, the less likely it is to have independent executor and waiver of bond in the same paragraph. It's usually in two separate paragraphs. I don't really know why, but that's just what I've seen. But you're looking for that. You're looking for the appointment of an independent executor, and you're looking for the waiver of bond. And does it actually give stuff away? A document that just says my name is Joe Smith and I appoint um, Jim Johnson as the independent executor of my estate and I waive bond and then doesn't actually say anything else. It doesn't contain any language that shows what we call testamentary intent. That's not a will. That's just I don't know what that is. It's just a piece of paper that appoints an executor. So, well, I take that back. It is a will, but it's a defective will, and you're going to have to deal with that. So, hopefully, uh, as you're looking at the will, it's the original. Um, it is from the state of Texas. It is signed by the testator and two witnesses, and then it has a self-proving affidavit attached. It has language that appoints an independent executor, waives the bond, and actually gives stuff away. And uh, hopefully it has what we call a residuary clause. Generally, wills will have specific bequests. I give my car to Sally, and then I give all other property to my children in equal shares. Just sort of a savings clause or a residuary clause that just kind of says anything I haven't specifically given away, I give to these people in this class of people in this manner. So so you've met with the client, you've gathered information, you've looked at the death certificate, you've looked at the will. Now we're going to start thinking about an application. And the application to probate a will is under 256.052. And these terms I am about to use are Jack Wilburn terms we use in our office. Uh, you may use different terms. You may have heard them called other things. We call the chef's kiss of wills the plain vanilla will. It names an independent executor without bond. It's the original. It names it's self-proving. It's from the state of Texas. It's everything that you're looking for to make it as simple as possible. We just call that the plain vanilla. Then, crap. Oops, this is the gulp. Sorry, there is one we call crap, but we'll get to that. The gulp, it names an executor, but it no doesn't name them independent. It just says, I appoint uh, Stan Smith as my executor, but it does not say the term independent, and it doesn't have a special phrase we're going to talk about here in a minute. Then there's it names someone as a personal representative. Um, Also not ideal, but we can deal with it. Then there's the dadgum. It names four executors, all of which are dead. And so we got to deal with that. Or the crap. It's from another state or worse, another country. Um, and so again, none of these are fatal. They just change the application form we're going to pull up and work with. And they move from easiest to most difficult. Um, there's We talked earlier just briefly about probating a will as a muniment and a title. If someone comes to you and it's been more than 4 years since the person died, and there's real property, you can you can seek to admit the will as a muniment of title only under Chapter 257 of the Estates Code. The there can't be any other debts. They couldn't have been on Medicaid. They can't owe child support. There's a bunch of little provisions to that, but essentially admitting a will to probate as a muniment of title only has no appointment of an administrator or executor. It just passes title to the people that are named in the will as the devisees. So it's a trick we use when it's been more than 4 years. And you also have to prove to the court that it wasn't the fault of the applicant that it's been more than 4 years. So it's a tool in our toolbox, but it's not a slam dunk. It's certainly not plain vanilla. It's not the easiest thing we do. So, and then I think one of the more difficult because of the that it involves and the hoops you have to jump through probating a copy of a will. So we talked earlier, you're looking to see if what you have in front of you is the original will. If it's a copy and they've torn up the house, they can't find the original, for whatever reason, all you have is a copy. There's some very specific steps you have to jump through. That is an entire CLE all to itself. I don't want to sidetrack us by going down that rabbit trail. Just know you can look at 256.054 and look at all of the special rules about probating a copy of a will. The notice requirements are different. You're going to get an attorney ad litem appointed. It's just much more convoluted. So always look for the original, but just know that it's not fatal if you don't have it. It just makes it more complicated. So let's talk about the plain vanilla application. Again, it's under 301 and 401 of the Estates Code. This is what I call the chef's kiss of wills. If somebody brings you a will and it's folded and it's wrapped in what we call a blue backer, really thick blue cardstock paper, and it's got like a design on the front, and it says from the law offices of Dewey, Cheatham, and Howe, and you know that, and it is on thick paper, you know that's most likely a good will that was drafted in a lawyer's office, and it's going to have everything you need, or at least that's what we hope. So prepared by an attorney, executed in an attorney's office. We're going to start from the proposition that it's right. And then, as Ronald Reagan said, we're going to trust but verify. So it names an independent executor to serve without bond. It has a residuary clause. It gives stuff away. It's signed by the testator, two subscribing witnesses, and a notary public. It's self-proving, therefore, and you have the original. That is just that's as simple. This is as simple as probate gets. This is the HOV lane of probating, and look, it's as easy as it gets. So let's talk about what the application has in it. You're going to look at 256.052. Now, this is just a practice tip that I've learned over the years. And by learned, I mean screwed this up and figured out that I need to pay attention to this and not be embarrassed in front of my client when the court points this out to me during a hearing. Hopefully, the name on the will matches the name on the death certificate. But not always. So, you know, my name, for whatever reason, my name is David Jackson Wilburn II. Do not ask me how a little baby is born and you look at a little baby and say, oh, I think I shall name him David Jackson Wilburn II. Anyway, but everybody in the world knows me as Jack. Because I know better, my will says the last will and testament of David Jackson Wilburn II. But maybe if I didn't know better, my will would say the last will and testament of Jack Wilburn. Well, how do you fix that? Um, how do you deal with that? Well, in the in the wise words of Judge Troby, the Associate Judge of Probate Court Number 2 in Dallas County, liberal use of AKA is always helpful. So your application starts with, you know, this is the probate, an application for probate of the last will and testament of, and then I use the name on the will of Jack Wilburn, AKA, also known as uh, David Jackson Wilburn II. And then every time I'm going to put the testator's name in that application, it has that whole phrase, Jack Wilburn, AKA David Jackson Wilburn II. This also applies to the applicant. So if I'm the applicant, and I'm colloquially known as Jack Wilburn, um, and my driver's license says Jack Wilburn, but I'm named in the will as the executor as David Jackson Wilburn II. You're just going to put in there AKA and just put it everywhere. Don't skimp. Ink is cheap and paper is cheap, so don't skimp on words. It'll make your life easier when you get to the hearing. Just ha everywhere that a person's name is, if there's any discrepancy between in the decedent, if there's any discrepancy between the death certificate and the name on the will, or for the applicant and the executor, if there's any discrepancy between what appears on their driver's license and the name they normally go by, just put an AKA in there. It'll save you and them a lot of trouble down the road. So, this is just straight out of the code book. You can go to 256052 and read this, but you got to have the applicant's name and domicile. And then they, as I mentioned earlier, the last three of the driver's license and social security number, if they have them. Testator's name, domiciled, and if known, the age on the date of the testator's death. Well, you should know that because it's on the death certificate. So, same thing again, you're going to need the last three of the driver's license on the social security number. Um, I try not to let perfect be the enemy of good. If my client doesn't know the last three of their driver's license number, and then I go to my services that I have that I can look things up and I can't find it, I just say, we don't know, and we move on. It's never stopped me from being able to probate a will, knock on wood. So, um, you need to list the fact, date, and place of the testator's death. So and so passed away on, January 1st of 2026 in Dallas County, Texas. Um, at the time of their passing, they were a resident in and were domiciled in Dallas County. Now, there's a whole bunch of different ways to determine venue, but the most common one is where did they die? Okay, that they own property. This, including a statement generally describing the property, in almost every will form I've ever, or application form I've ever seen, it just says testator owned property exceeding $10,000. Um, and the date of the will. What date was the will executed on? Um, the if there's what we call a well, if the applicant is different than the executor, you're going to have to say, well, here's who the executor is, and here's their name, here's their address. 99 times out of 100, the applicant is the person named as the executor. But if they're not, don't forget to put this in there. The name of the subscribing witnesses, if they're there, well, I guess that would only apply to a holographic will. So if you're probating a regular plain vanilla will, you're going to need to list the names of the witnesses and their last known addresses. And then number 9, this is about pre-termitted children. Generally, the way you're going to see this in an application is no children were born to or adopted by the decedent after the date of the will. But if they are, you're going to need to list them. You're going to need to talk about divorces. Were they divorced after the date of the will, or was any marriage dissolved after the date of the making of the will? And if so, you're going to need to list all of that information out. Um, does that will name the state, a governmental agency of the state, or a charitable organization as a devotee? And you need to list out the name of the executor named in the will. Um, and you need to state that they're qualified and not disqualified, suitable and not unsuitable. So those are all the parts of a plain vanilla will. I'm about to have to kick it up a notch because time is flying by quickly. So another kind of will you might find is it names an executor, but it doesn't say the term independent. That's going to be under 401.002A, what I call the close but no cigar will. The court can appoint the executor, uh, but all the devotees have to agree to their appointment for them to be independent. Otherwise, the default is dependent. And I don't need to tell you, or maybe I do. Dependent is to be avoided if you can. So we're going to do everything we can to try to get this thing to be independent. Um, Now, if you've got devotees under that will to the under that will that are under the age of 18 or are incapacitated, in Dallas County, you're not going to get an independent administration that requires the consent of anyone who's under the age of 18 or incapacitated. I want to make sure you hear that correctly. If the independent executor is named in the will, you're not going to need any of this consent. This is only if they're named, but they're not named as independent. That's when you're going to run into issues. Um, Most of the courts in North Texas will not appoint an independent administrator if there is a minor and an incapacitated devotee. That's just the way it is. Uh, Hopefully the will, well, generally speaking, what I've seen is if it doesn't name them as independent, it doesn't waive bond. So as you're seeking waivers from your devotees, you're going to want them to designate someone, consent to them to serve as independent, and waive that bond as well. We call that form a designation, consent, and waiver. Um, it's a standard form that is used in tons and tons of probates. Okay, same idea. The will name someone, but it uses the phrase personal representative. This is what I call internet junk. Um, this is essentially, if you're looking at this, sometimes this will is just a big bag of nothing. It is not drafted well. Somebody pulled it off the internet. Uh, the new bane of lawyers' existence is Chat GPT. Um, so, but don't despair. We got a fix for this. As long as it names the person, again, we can get waivers from the devotees to have them appointed as an independent executor. However, there's a little trick here. Sometimes wills have this what I call the magic phrase. Um, if it says that no other action shall be had in the probate court in relation to the settlement of this person's estate other than the probating and recording of the will and the return of a required inventory, appraisement, and list of claims, that is the same as saying independent executor. So, if you've got that phrase, you can file an application for independent executor, and generally you'll be okay. If it just says personal representative and it doesn't have this magic phrase, you're back to getting designation consents and waivers from the devotees, hoping nobody's a minor, hoping nobody's incapacitated. Um, so we're just hoping against hope that everything's okay. Again, if you've got a minor and incapacitated person, you're not going to get an independent if it's not listed in the will. Um, and you're going to need to get designations, consent, and waiver. If there's five devotees under the will and you get consents from four of them, you don't have consent and you're going to be and you're going to end up with a dependent administration. It's all or nothing in this situation. It's not majority rules. It's not, oh, well, I got most of them. It's all or nothing. And uh, we've all been there. Just be aware of that. Um, this is this is the problem with the old wills. You got a will from the 60s. Somebody lived to almost 100 and everybody they knew is already dead. That's okay. We can again have the devisees under the will um, consent to an independent administrator. Here's my little nerd thing for the day. An executor is someone who is named in a will. An administrator is someone who is appointed by the court. So if all of your named executors are dead and you're having your uh, devisees consent to an independent administration, that person's going to be an administrator with will annexed. In the previous two examples, if they're named as executor but not independent, if they're named as personal representative, they will end up being an executor. Um, the only time you're an administrator is when the court has to appoint you because you were not, your name does not appear in the will, or their name does not appear in the will. In this instance, there's no named executor who's still living or willing to serve. Sometimes you've got somebody who's still alive, but they're like, I'm not touching that with a 10-foot pole. And then you're back looking for designations, consents. And just in case you didn't hear it the first two times, I'm not aware of any court in North Texas that is willing to appoint independent administrators when there are minors or incapacitated individuals. Your mileage may vary. That's just my experience. Um, so that's what I can tell you about that. And again, you're going to need a signed and filed consent by the devisee. It needs to be on file with the court before you get to the hearing. You can't show up and say, hey, did you talk to everybody and they said this is cool? No, it's going to be a literal signed and notarized document that you file into the case that the judge can see. And then they're going to say, okay, we're cool. All right. And if you can't get it, if your executors are all dead, if your named person is not named ex independent and nobody will consent, or you can't get everybody to consent, you're going to end up with a dependent administration. This requires a corporate surety bond. It's expensive and time consuming. Again, I said an entire day could be dedicated to dependent administrations. You could spend a week talking about the ins and outs of dependent administrations and what needs to be done and how they need to be done and how complicated they can be. So we're going to try to avoid them with those tricks I just gave you. Now let's talk about filing. So we've talked to the client, we've looked at the will, we have drafted the appropriate application based on the facts and circumstances. We've already gotten our consents on in-house that we're going to need, and now we're going to file. You know, nowadays, uh, everything's going to be by e-file. I remember in the good old, well, I'm not going to say the good old days. Back in my day, when my beard wasn't white, you would go to the courthouse with your application and the original will and a copy of your application and a copy of the will, and you would hand it to a clerk. You would hand them a check. They would file stamp everything, and then you would go around and talk to the docketing coordinator, and you would set your hearing right then. Those days are past. I don't even know why I just told you that. But you're going to e-file your application. Now, you may or may not know this, so I'm going to tell you. Under Texas Rules of Civil Procedure 21F12, you've got 3 days to get that original will to the clerk from the time your application is accepted. So you're the boss of how that gets done. I know lawyers that will not let that will out of their possession. They take it to the clerk themselves and they deposit it with the clerk. I know people that use FedEx. I know people that use certified mail. I know people who use courier services. So however you do it, Pony Express, whatever, um, get that will to the clerk within 3 days after it's accepted. Um, in Dallas County, when you file your application, you're also going to file a little form that is a citation request form, and you're going to ask for posted notice. This is under 258.001. There, it varies depending on which version of a will application you're doing. There's one kind of posted notice for the plain vanilla. There's one for a copy. There's one for foreign. So just make sure you're asking for the right posted notice. Make sure that if you've done an AKA, make sure that it's captured in there. Make sure that everything is right. Make sure the name is spelled right. Review that so you don't have a problem with your hearing. The return date, that posted notice gets posted and it returns the first Monday after 10 days go by. So it gets posted. The easiest way to think about this is whatever day it goes up, you count 10 days, and then you go to the next Monday. If it's posted on a Thursday, your return date's going to be on a Monday. If it's posted after Thursday, it's going to be the following Monday. And the only reason that matters is you can't have your hearing until after the return date. You can't file a application for probate on Monday and have a hearing to probate it on Tuesday. So just be aware of that. Hearing dates. Now, again, we're talking about Dallas County probate. And so in Dallas County and pretty much in every county I practice in, before you can get hearing dates, you have to e-file your proposed hearing documents, which are your order, your proof of death and other facts, your proposed qualification addendum, and your proposed oath. You've got to e-file all of that, and then you can email the court coordinator and ask for hearing dates. And then you go back and forth a little bit. Here's the dates we've got. Well, none of those work for us. What about this? And then finally, you set a hearing, and you can either have your hearing on Zoom. Every court in Dallas County offers hearings by Zoom or in person. You can appear in front of the presiding judge, or you can appear in front of the uh, the associate judge. So you've got choices. If it's going to be on Zoom, you're going to need to file a little document called a notice of electronic hearing. And if you're going to appear in front of an associate judge, you're going to need to file another document called a waiver of de novo appeal. That just means that you're going to appear in front of the associate judge and you're not going to appeal the ruling. Um, or there's not going to be a de novo appeal. Now let's go to the hearing. So it's either in person or on Zoom. It's either going to be with the presiding judge or the associate judge. You're gonna elicit testimony. Essentially, you're just going to run them down through the facts that are alleged in the application that are also listed in the proof of death and other facts. Um, Now, let's talk about this. If your will is not self-proved, meaning it was signed by the testator, if it's a printed will, if it's a typed will, it's signed by the testator and two witnesses, but it is not notarized, it's not self-proved, you're going to need to either bring a subscribing witness, the notary, or if you can't find any of those and can prove to the court that you couldn't find them, you're going to need to bring somebody to court that knew the testator, knows their handwriting, and knew that on the date that will was executed, that they were over the age of 18 and of sound mind. So just be aware of that as you're getting ready for the hearing. I can't tell you how many times I'm like, oh, dad, I forgot this one's not self-proved. So always keep in the back of your mind, if it's not self-proved, you're going to have to jump over an extra little hurdle. And the only reason this matters practically is you got to make sure they know about the hearing. There's always that little bit of panic where you've set the hearing and you're about to click the Zoom button to get onto the hearing, and you're like, oh, wait, did we invite the subscribing witness? And because I have three absolutely amazing paralegals, the answer to that is always yes, because I'm not in charge of that. Somebody smarter than me is. Um, your main goal in doing all of this is to get the judge to enter an order. That's a form you'll get from DVAP when you submit it. The will essentially says that the testator has died, that they left a valid written will, that it is admissible, that it's been admitted to probate, and that the person named as the independent executor is qualified and not disqualified, and suitable and not unsuitable, and it directs the clerk to issue letters testamentary um, once they take the oath. And the oath is different depending if you're an independent executor or if you're an independent administrator with will annexed. Um, but just be aware of that. It's always embarrassing to have the wrong words in your oath because you forgot what kind of will you're admitting. Um, if the bond isn't waived in the will, the court's going to ask questions about setting the bond amount. You're going to need to know information about the assets, and the court's going to require a bond, and you're not going to be able to get letters until you submit that bond. It's most commonly going to be a corporate surety bond. Um, this is just practice information. If your application lands in probate court number one, when you want to set a hearing, you're going to reach out to Miss Amanda, and there's her email address. There's the website. Go to that website, read it. Most of the questions you have are going to be answered about what you need to do and how you need to do it in terms, especially for a Zoom hearing. Probate court number two is Mr. Traylon Mathis. Uh, Same idea. Look at the website, look at what their specific requirements are. Most of this applies to Zoom. Each court's a little different about how they do their Zoom hearings and what you need to do and how you need to deal with the documents afterwards. Just read that. It's pretty self-explanatory. If you read what they wrote and you do what they wrote, you're going to be fine. Finally, in probate court number three is Miss Peggy Johnson. Same idea. Go to their website, look at what they're telling you to do, and do it. Um, we finally reached the end where we've been to our hearing. The judge has taken mercy on our poor little souls and signed an order admitting our will to probate. If you've had an in-person hearing, you just walk around to the clerk's office and you have letters issued immediately. This is assuming that the bond was waived. If it's straight vanilla and an independent executor is named, you're getting letters testamentary. If it's an independent administration, you're going to get letters of independent administration with will annexed. And if you have a Zoom hearing, the thing that's been beaten into my head over the past couple of years is hold your oath that's signed by your client. Don't e-file that until you see that the judge has signed the order and it's been uploaded to the system and you can see it on the system. Then you can e-file your oath. If you try to e-file it before then, it won't get accepted. Uh, so again, this is all listed on the websites of the various courts, and you just do what you're told. You'll be fine. So like I said, make sure you hold the oath. Here's a little timeline. If you're visual, you're going to meet the client, you're going to file the application, request posted notice, you're going to deliver the will within 3 days, you're going to e-file the proposed hearing docs, you're going to set a hearing, you're going to attend the hearing, you're going to get letters. It seems so simple when I'm sitting in my office talking to you with in a vacuum, right? It looks so simple on that little thing, but there's always little idiosyncrasies to each of those. And then uh, just so you're aware, getting letters is just the very beginning. It's like just getting to the starting line of a marathon. Now you get to administer the estate. Um, you have, once your client is appointed as the executor or the administrator, they have lots of duties. They have to post notice to creditors. They have to send notice to the devisees under the will. and you have to let the court know that you did that. You can send permissive notice to creditors if you want to. Most importantly, you owe an inventory appraisement and list of claims, or what's called an affidavit in lieu within 90 days. And so I know I talked fast and I talked about a lot of stuff, but that is the general principle that will get you where you need to go. For once in my life, I finished on time like I was asked to. Um, oh, the one comment, you're connecting and you're not alone. So thank you for that nice feedback. But if you do have any questions, um, then the most important question anybody ever has is what's the MCLE number? And it is 174310462. It's in the, what do you call that? The chat. Is that what you kids call that little box that just popped up?
That is correct. Thank you, Jack. So yes, the MCLE course credit number is in the chat function. Please enter any questions you may have through the Q&A box, and we can get those answered before logging off today. But a copy of today's presentation will be provided to all attendees, which does include Jack's contact information as well. So if you have any questions following this afternoon, you can reach out to him as well. Let me pull up Q&A real quick.
There it is.
Yes, Jack's contact information is listed in the PowerPoint presentation that will be provided to all attendees.
Did I put that in there? Maybe I put my email address, hopefully.
You put your email address, yes.
Well, and get your questions in quick because you know, I've got to start making the toys for the kids that you know, come fall. So I know I'm Santa Claus's doppelganger. So just get your questions in quick. Does the probate clerk do a CLE on how to file? Unfortunately, no. It is, quite frankly, it's trial and error. But there, if your e-file service might have like a little FAQ, Q&A thing as when you pull it up that'll tell you kind of how to do it. And each county's different. And if I would be lying to you if I told you I knew how to e-file a will for probate. I haven't done that myself in a couple of years because I have amazing uh, people that do it for me. It's just trial and error. And if they reject it, they're going to tell you why. So um, I bet Maricela has a better answer than that.
Yes, I do want to plug in that as a DVAT volunteer, you do get access to both of our mentor attorneys, Kristen and Chrisan, who can give you instructions, especially if you've never e-filed before, on how to do so and walk you through that process. So, great plug for DVAP as well. We have additional resources at any point through your representation. Looks like we have one more question.
Okay. What evidence do you provide to overcome the 4 years after death default on immuniment? Um, anything, not to sound like a jerk, anything I've got, um, the most successful evidence I've had is that they didn't know they needed to do it. Like, either uh, they just didn't need to file it, and maybe they talked to a lawyer and were told, well, there's really nothing to probate here, you'll be fine, and it was just not great advice. Anything you can say that says this person did not know that it needed to be done and it's not their fault, that you can show that they're not, that it wasn't a dereliction of duty, the courts may take mercy on your soul. But that is just God, may the odds be ever in your favor, as they say. You just got to throw everything you've got against it and hope one of it hits the judge's ear just right.
Thanks, Jack. See
Is
one
it
more.
difficult to probate a will? Okay, that's a whole nother that's a whole nother CLE. Generally speaking, you probate it here and then you do what's called an ancillary probate in the other state, and every state has its own little rules for how you do that. but it generally involves first admitting the will to probate here and sending certified or exemplified copies over there. So the simple answer to that is yes, it's difficult, but not impossible.
All right, perfect. Thank you everyone for attending today's presentation. As I mentioned, you will receive a copy of the presentation. Jack, again, thank you for your wonderful presentation, and we hope everyone has a good rest of their afternoon.
Thank you, Maricela.
Bye,
Have a
everyone.
great day.